Oppenheim defined the international law as the body of rules which are legally binding on states in their intercourse with each other. These rules are primarily those which govern the relation of states, but states are not the only subject of international law. International organizations and to some extent, individuals may be the subjects of international law. There are a number of respects which illustrate the key differences between the international law and the municipal law, such as there is no single body able to create laws internationally binding upon everyone. Moreover, there is also a lack of a proper court system with comprehensive and compulsory jurisdiction to interpret and extend international law. These differences actually lead to a dominant question, which is, how are we going to ascertain the sources of international law? In fact, Article 38 Clause 1 of the ICJ Statute could be the starting point in answering this question. It is currently the most authoritative and complete statement as to the sources of international law. The Article 38 Clause 1 provided that treaties, custom, general principle of law, judicial decisions, and the teaching of the most highly qualified publicists of the various nations are all sources of international law. It is noteworthy that Article 38 categorized the judicial decisions and the teachings as subsidiary means for the determination of rules of law. So we could say that there is a hierarchy for the source of international law, and the treaties are of utmost importance, while customary international law is the second most important source for international law. However, is it true? Are there really a hierarchy norms in suggesting that the treaty rank higher than customary law? We will discuss it at the later part of this video by comparing their respective effectiveness in regulating international law. We will first start to explain how treaties serve as a formal source of law. So treaty is basically an agreement between parties on the international scene, and it is known by different names ranging from conventions, agreement, protocol, pact, charter, and a lot more such as declarations and covenants. In modern international law, treaties are undoubtedly the most common source of international law. In certain areas of international law, such as international environmental law, they are exclusively regulated by treaties. Other evidence that a treaty acts as a source for international law can be referred to the case of Valenfort and others against Germany, where the arbitration tribunal held that it was unquestionable that international conventions or international treaties concluded by and between sovereign states constitute international law. Similarly, when we look at the Vienna Convention on the Law of Treaties 1969, there were only 116 states that are parties to this treaty. Although less than half the states in the world are parties to it, it is actually applicable to all states whether they are parties to the convention or not, because every court in the world has treated the main provision of the Vienna Convention as codifying customary law. This was a great example to show that the treaty is evidently a source of international law. Moreover, treaties constitute a source of law because they operate in line with a fundamental rule of customary international law, which is known as pacta sunt servanda, which requires the treaty parties to perform their obligation in good faith. In fact, we could also see the shadow of this principle under Article 6 of the Vienna Convention and the Article 2, Clause 2 of the United Nations Charter. Article 18 of the 1969 Convention further required the states to refrain from doing any act which would hamper the outcome of the treaty. In addition, in the case of certain Norwegian loan case, which is France against Norway, Judge Lauterpacht also made it clear that it was unquestionably the obligation to act in accordance with good faith being a general principle of law. Following these examples, which impose an obligation on the parties to honor their treaties in good faith, this actually left no room for debate in suggesting a treaty is a source of international law. However, further explanation is needed to clarify why it is being described as formal. One of the reasons is because it actually bears a close resemblance to contracts in a superficial sense by being binding upon the contracting parties of the treaty. Article 2 of the Convention also defined the treaty as an international agreement concluded between states in written form. The emphasis on the written form helps the party to acknowledge their obligations and any underlying event such as the consequence of the breach of treaties. The requirement of written form could be extended to the third states too. Generally, a treaty does not create obligation for a third state without its consent by virtue of Article 34 of the Convention. Nevertheless, Article 35 pointed out that an obligation may arise for a third state from a term of a treaty if the party to the treaty so intend and if the third state expressly accept that obligation in writing. In other words, for an obligation to be imposed by a treaty upon a third state, the express agreement of that state in writing is required. Hence, we could see that the formation of a treaty always requires written instrument, and this requirement is itself suggestive of the element of formal. Moreover, the treaties are formal because most of them were also enumerated in a fairly consistent format. For example, the treaties will start with a preamble, which included the shared objective between states in executing the treaties. The article of a treaty also usually use the words done at the end, and the date is written in its most formal non-numerical form. For instance, we can see that the end of the Charter of the United Nations reads, done at the city of San Francisco, the 26th day of June, 1945. In addition, there is also a requirement of signatures from the states, from the state representative at the very end of the treaty. We shouldn't underestimate the act of a signature, although in most of the important treaties, the signature is referred to as a simple signature and not definitive signature. Simple signature would not amount to a consent to be bound. For example, US President Bill Clinton once signed the Rome Statute but did not submit the treaty for ratification, and therefore there were no legal obligation arising from his signatures. However, according to Article 12 of the Convention, when the negotiating parties to a treaty agreed that signature shall have the effect as consent to be bound, then the signature established the treaty. Other than that, a treaty is a formal source of law because only the person who has full powers according to Article 7 of the 1969 Convention is capable of representing their country to go and conclude a treaty with other states. This provision ensures that the other parties to the treaty feel secure because they are actually making agreements with persons competent to do so. For example, in the UK, the treaty-making power is within the prerogative of the Crown, whereas in the United States, the treaty-making power is vested in the President, and he would need to act according to the advice and consent of the Senate. Following this reasoning, any treaty made by a person not authorized as required will be without any legal effect. There was an interesting instance where the legal effect of the treaty was questioned in 1951 because the International Peace Treaty was signed by a delegate who only had authority from Norway but not Sweden. Lastly, by virtue of Article 102 of the Charter of the United Nations, the treaty is a formal source of law in the sense that there is a requirement to register every treaty and every international agreement as soon as possible with the Secretariat and publish it. The sanction for failing to do so is that any treaty that has not been registered cannot be invoked before an organ of the United Nations, such as the International Court of Justice. By having such a registration rule, it is itself indicated that formalities are involved, and the treaties in this way serve as a formal source of law. Here we come to the next question. Is it true that a treaty is more effective than customary international law? I submit that although there are some differences, but most of the time both of them are equally effective. The treaties and customary international law are indeed importantly different as lawmaking processes, but they are not so different with regard to compliance and enforcement. For now, I'll elaborate on why I feel that scholars actually overstated the distinction of the effectiveness between treaties and customary international law. There are many instances where the customary rule actually developed from a treaty, especially when many states act in a consistent manner with regards to the provision of the particular treaty out of a sense of legal obligation for a long period of time. For example, we know that territorial sovereignty is a customary international law for centuries, but in fact, it is also important to know that the idea of territorial sovereignty is actually established through the Peace of Westphalia 1648. This concept of territorial sovereignty later became global norms. Moreover, the Geneva Convention was also a significant example to show that a transformation from a treaty to customary international law is possible, as it was adopted by the United Nations Security Council in 1993 as customary international law. The effect of such transformation is that parties which have not ratified said treaty will be bound to observe its provisions in good faith. Hence, what I want to emphasize is that at the end of the day, no matter the treaty or customary international law, both of them created binding obligations. Similarly, a treaty usually codifies the existing customary law, organizing the legal area and affirming its crystallization. In other words, a treaty could be treated as merely a device for the codification of existing customs and thus they have no actual differences in effectiveness. Joel Trackman also agrees with the view that the vast majority of customary rules have now been codified. For example, much of the customary international law of human rights is subject to the reporting and monitoring mechanisms established by human rights treaties. Codification, therefore, means that many customary rules can in fact be enforced as treaty rules. Next, citing an insight from Verdier, a state may comply with a customary rule because it knows its decision to defect creates a precedent that may undermine a cooperative norm it values. In other words, the true reason why the states comply with the customary rule is because they worry that their cheating may lead to the rules erosion and might cause them some bad consequences due to the violation. This insight could be applied exactly to the treaties. So the reason why a law is effective is because it brings consequences to the compliance or non-compliance, not because it is customary international law or a treaty. However, let's be picky to look at why many scholars suggest that treaties are more effective than customary international law. Firstly, like what William Friedman suggested, custom is too clumsy and slow-moving to accommodate the evolution of international law when compared to the treaty, because treaty is a more modern and more deliberate method to create law. However, this is not always true in a modern international law today, because the states in many occasions could have expressed their views as to customary international law through General Assembly resolutions. For example, in recent years, there has been a stream of resolutions from the UN General Assembly purporting to set forth, confirm, or reaffirm rules of customary international law. By this means, a so-called instant custom which prescribes valid rules without having to undergo a long period of gestation will be established. Moreover, there are certain circumstances in the absence of state practice, but customary law could be formed. For example, the principle of non-sovereignty over the space route became instant custom soon after the launching of the first Sputniks. So by having such a mechanism to produce instant custom, I submit that the argument saying that a treaty is more faster method, thus more effective, became merely a history. Secondly, the treaty was more effective than customary international law in the sense that it allowed the reservation to take place by virtue of Article 2 of the Convention. This will effectively encourage as many as possible states to adhere to the proposed treaty because the states were able to exclude an unsatisfactory provision in the treaty. For example, CEDAW was ratified by Malaysia with reservations to comply with the Federal Constitution. There was no such a reservation mechanism for customary international law, but it is not always a bad thing because customary international law could be used to create rules binding on whole-out states. For example, there may have been no basis for legally coercing South Africa to end apartheid in a strictly treaty-based international legal structure, as the state was unlikely to sign onto a treaty that condemned its own actions. It is worthwhile to note that actually customary international law is not always applicable to coerced whole-out states too. It is applicable to the whole-out states only when the whole-out states violated jus cogens such as slavery, genocide, torture, and others. Otherwise, states can actually deviate from customary international law by enacting treaties and conflicting laws due to the fact that not all customary international laws rise to the level of peremptory norms. This makes treaty and customary international law look exactly similar because any treaty which violated jus cogens will become void too. Lastly, the Charter of the United Nations established the International Court of Justice, and this court system produced through treaty effectively and peacefully settled the disputes between member states because the states are obliged to abide by the court's decisions. Hence, by entering into a treaty, disputes are more likely to be settled in a manner akin to the domestic court. However, is it true that treaties are always effective in settling disputes? I submit that the answer shall be no. For example, the United Nations Convention on the Law of Sea, UNCLOS, was being criticized as a failure due to the fact that there is a significant and consistent pattern of non-compliance with its provisions. This could be seen in a recent issue where China violated the provisions of UNCLOS by using its military and its China's fishing fleet to enter the grey zone. In 2016, the International Tribunal at The Hague already ruled that there was no legal basis for the 9-dash line claim, but China rejected the decision and continued to allow the Chinese vessels to infringe other countries' waters. Hence, we can see that the treaty loses its effectiveness in creating a binding court decision to settle dispute when the violating state is a powerful state like China. On this issue, even the US faced difficulties in attempting to pressure China over its rejection of the ruling because Washington itself has not ratified the treaty. So in conclusion, I stand still with my view that actually the treaty and customary international law are equally effective because they always influence each other. In fact, in Nicaragua against United States, the court held that the treaty and the customary international law will exist separately, indicating that they are both equally important and equally effective.